Right, good afternoon, everybody. We're going to go ahead and get started. So I thank you all for attending. As per our last practice manager learning communities, we also have some folks attending remotely from our Northampton office as well as our Bridgewater office. So with that said, if you do have questions, and we really want this to be you to be as engaged as possible, and so we want you to ask questions. What we'll do is we'll have the speakers stay here so that the other practice administrators can hear us from their locations, and we'll ask them to just repeat your questions so that way everybody else can hear us on their end. With that said, we're really excited today to be talking about pediatric HIPAA and compliance planning. I'm not the professional in these topics, so we have brought in some professionals with a wealth of knowledge in this area and experience. One of the great things is that after the presentation, they're going to give us some documentation that you can bring back to your practices and use and reference as you're, implementing some of this stuff at your own practice. So today, we will also have Nicole Pelletier, who's from our PPOC Patient Safety Program, give a quick overview of that program. Some of you may have worked with her in the past. So she has logged in remotely, and once we get there, she'll go ahead and give us an overview of that program. If you have any questions for Nicole, please feel free to ask. We'll talk about privacy as it relates specifically to our day-to-day. So out there in the pediatric environment, you all know that it's a lot different dealing with pediatrics versus adult medicine, and so we're really hoping to bring topics that are relevant to your day-to-day life. And then the compliance plan. Some of you attended our presentation earlier this year in March, where there was a mention of a compliance plan, and then after that we got a lot of questions about the compliance plan and what does that mean, and so we will be talking about a compliance plan today. And then your homework, of course, which I'm really happy to say should be super easy, and we'll get to that towards the end of the presentation. Before we get started, you should all expect it. Every time I meet with you, every time I see you, I remind you that we have a pilot forum that we've opened up to practice managers called Open Pediatrics. I'm excited to say that there have been some really great discussions on there since we've launched it. It seems like more people are going in there and discussing with their peers issues going on in their specific practice. As you can see on your screen, there's some information that I will share with you, or Emmy, our communications person, but we have practices talking to each other about what are you doing with your old medical records? How long are you keeping them for? What are you doing for soundproofing in your offices? Do you have somebody that you've worked with for construction? Things like that. So we hope that everybody will go ahead and create an account in Open Pediatrics. You can then email myself or Emmy Llewellyn, and we can add you to our group. It is a private group, so you have to be added in by one of us. And I wanted to put this to your attention quickly. In June, Boston Children's is giving a presentation specifically related to transitioning patients to adult care. This is something that we have on a docket for a learning community, but I wanted to let you all know that they are offering this free program. We put it into the roundup, so there's instructions there on how to register if anybody in your organization is interested. It's a free program, but my understanding is that there's a limited amount of space available. So if it's something that you're interested in, your clinicians, nurses, care coordinators, the information was in the roundup that you should have received at 6 a.m. this morning. And our learning community schedules, hard to believe we're already on our third learning community. That means we have 3 more. Our June session will be online via webinar, so you can attend right from your offices. And then we'll skip July and August. It's just a really challenging time to get everybody to attend an event like this, and then we'll pick it back up in September. We'll let you know what the topics are via Open Pediatrics, the roundup, and then of course we have a practice manager meeting coming in June, which I'm sure we'll talk about it a little bit at. Great. So I'm excited to announce both Todd McDonough and Wix Moffitt. Todd is going to start out our presentation. He'll give a quick introduction of himself. As you can see, he's a principal and CEO at Healthcare Compliance Network. So please come up and join us, Todd, if you are ready.
Safety people aren't going.
Oh, yes, they are. I'm sorry. Thank you. And he just reminded me that Nicole is going to give her presentation first, so apologies about that. I just said it. So Nicole, if you can go ahead and unmute yourself, we are all here and hopefully we can hear you okay.
Hi, Leah. Can you hear me?
We can. Thank you.
Great. Hi, everyone. My name is Nicole Pelletier. I'm a senior QI consultant for patient safety at the PPOC. And I work with Cheryl Smith, our PPOC patient safety manager, to manage all things patient safety. So I know I've worked with a lot of you in the past. Some of you may have attended our ambulatory risk management learning community. To just put in a little plug, we are offering that learning community again starting in September, and it'll be held in Burlington. So if anyone is interested in participating in that learning community, please feel free to reach out to us. We open the learning community to all members of the practice, so clinical, non-clinical, yourselves, MHCCs, nurses, front desk staff, providers, anyone can attend. If you'd like more information, please reach out to us. But I just wanted to remind you today, as we're talking about privacy and compliance, about some resources that we offer at the PPOC. So as part of the patient safety program, you can always call us if you have any kind of more traditional patient safety concerns. So regarding to, medical errors, patients that may have an unfortunate outcome, anything like that, or even a near miss. But we also do provide consultation on some more risk-related manners, so things related to confidentiality, sharing of information. And a lot of these situations, they're situations that we've encountered before, so we may be able to provide you some guidance. If not, we can help connect you to other resources, whether that be, your malpractice insurer or an external legal resource to help answer your questions. But I just want to remind you that we're always here as a resource for you. You can email us or call us. This email and phone are monitored 7 days a week, so anytime, please feel free to reach out to us. And if you have any specific questions, I'm happy to take questions now, or I know that we have a great presentation that I think is going to answer a lot of your questions as well. So I'll pause for a minute to see if there's any questions before we move on.
Any questions in the room? No? Great. Thank you so much, Nicole.
Thank you.
Okay, so apologies about that. Let's go back to Todd. Thank you, Todd.
Good afternoon, everybody. We appreciate having the opportunity to come out to talk to you. I just wanted to give you a quick bio on who I am. So I have been involved in healthcare for probably going on over 20 years now. My initial phases were in the nursing home business. So had a lot of opportunity to be able to understand the aspects that happen in regards to that environment. And that environment is a unique scenario in terms of compliance, is where sort of I got my first sort of understanding of how much the state feds can sort of intervene in your world to sort of disrupt what you do. And every year, typically for about 5 days, usually it was about 5 days. If it was more, then you were in big trouble, but you'd have the DPHA come in, and you always felt, fairly well scrutinized by their activities. Then I spent some time in a practice environment. So I've lived in your shoes. I know what you go through in a lot of respects in terms of running your practices. But today, what we're going to get into today is we're going to talk about the privacy issues as they relate to PD groups. And one of the beauties of this is that we actually have clients that are part of the PPOC. So oftentimes, as their compliance company, we are fielding questions for them and trying to understand some of the nuances that sort of go along with the PD world. So in this presentation, what we tried to do is reached out to those individuals to have them give us some questions. One of the sort of main elements that we'll get into are those things that were sort of common. I mean, there's a lot of different things. There's, how do you deal with nurses? A lot of times there's those things. But what we wanted to do for this agenda was to sort of focus in on some of those areas that are around medical record release, and the areas that are sort of most important for you, DCF elements, some of those elements that don't go around with adolescent consent and then at 18 years old. But before we get into it, I want to give you guys a brief kind of rundown on the current state of HIPAA. Because HIPAA is not going away, as much as you all may believe that would wish it to go away. HIPAA is still entrenched. HIPAA is going through a little bit of its own evolvement right now, because the world that it sort of created really kind of put the teeth into it back in 2003 when the high-tech stuff came through, which is all the security things, because they had to react to the electronic world. They had to react to what was going on with electronic medical records. So at that time, there was a sea change that was going on. How do we deal with all of this privacy that now is not going to be handled in a physical form, and now is going to be out there potentially going in emails and faxes and other ways that are sort of distributed through systems? Fast forward to 2019, now the sea change that's going on with HIPAA is now they're dealing with what you guys may have heard of, the Internet of Things. So those types of instrumentation that's out there, the first thing that comes to mind is Alexa. And some of these devices that are being used to create efficiencies within the healthcare environment. All of these commercial players are coming out and utilizing these systems. But when they made the rules for HIPAA, they didn't think about, you know, the standard company that was going to be looking to try to keep to create a system that would keep people in place and let them stay at home using the Alexa system. So they're going through sort of a whole understanding of what their world may look like, sort of going out into the future. So it will require them a lot of sort of internal, you know, working with the National Institute of Safety and Technology, which they're very much dovetail with, in creating the elements that sort of are required for you as covered entities. So it's an interesting time, and one you really kind of want to be clear on as you guys start moving and start sort of introducing different types of technologies into your practices. Telemedicine is a big area. Things where you're interacting more through some of these devices like Alexa and things of these nature. So there's a lot of stuff happening on there. But most importantly, the things that we have up here are do you have your business associate agreements in place? People feel relatively comfortable about what a business associate is here. And I get nods of heads, shakes on that. Yes, yes, okay. There's a difference between a business associate and a vendor. But what's critical about this, and this is probably something you guys, you know, are well aware of, you've got your agreements in place, is that now, and it was just recently told to us, because as an organization, we often will go out to different trade shows to kind of learn what's happening in our space. And at a recent event here in Boston for the HIPAA Compliance Association, there was a member from Medicare who stood up and said, if as an organization you have business associates, are you aware that those business associates are actually doing what they need to do in terms of minding their shop around HIPAA? So we as an organization have been kind of waiting for guidance on this through the Office of Civil Rights. But we ended up hearing it through a very high-level senior person from the Center for Medicare Services, Medicaid and Medicare Services. So you have to think a little differently. I don't particularly agree with this, but that's my feeling on this is if someone is going to sign that business associate agreement, it's a binding contract that says they have an obligation to do X. They signed it. You guys have that. If there's something that happens with regards to the information that you're exchanging with them and they breach that, hopefully they're getting in touch with you. But what we're hearing is that you actually kind of have to do, not kind of, you have to do an audit of your BAs to make sure that that they've got policies in place, that they've got training in place, and that they are actually doing a security risk assessment. Doesn't mean that you have to sort of get on the phone with them, send them a checklist, because again, if they check off that they've done that and signed on it, then you have covered essentially your obligations as a covered entity, okay? So I just throw that out there because a little bit of a change on there. And if you're ever concerned about who a business associate is opposed to a vendor, you can always send that to Leah or Anna, and we can get in touch. And we do this all the time for our clients. We'll go through their AP list and sort of go boom, yes, no, yes, no, yes, no, yes, no. Typically, for practices your size, you should only have about anywhere from 6 to 10 business associates. If you've got 20, you probably have people that you've sent a business associate agreement to who don't fall into that category. Okay? Any questions about that? Okay. The second thing that I have on here is, are you working on your risk management plan? This is a trick question. Where does the risk management plan come from? Anybody want to hazard a guess to that? Nobody wants to jump in on that. Well, I throw this up there because all of you hopefully are doing your security risk assessment. Okay, everybody knows what the security risk assessment, it's part of your HIPAA obligation. Not only is it part of your HIPAA obligation, but it's also part of your MIPS macro obligation. Y'all remember that several years back when Meaningful Use was out there and they were auditing the practices based upon the docs and who was attesting to in Meaningful Use? Well, one of the things that we saw quite a bit of was that people were checking off that they did their security risk assessment, but guess what? When they came back and did the audit, and the government does this, is that they have the right, because it's their money, they set the rules, they have the ability to be able to be auditors. They came back and said, okay, you've told us that you attested to the security risk assessment. Did you do it? Show us the documentation. If you couldn't produce that documentation, that doc was giving that money back. Same thing is true with MIPS macro, just a whole different sort of level of change here. We've gone into value-based. This year is kind of, well, actually 2018 was kind of the past year. 2019, at some point here, that audit is going to come back to you. There's going to be someone, they've already identified a group, an organization that's going to go back in and audit organizations to make sure that you are minding your P's and Q's to what you're attesting to. And if you haven't done your security risk assessment, that's going to spell a bit of an issue for you. You guys have it unbelievably well because you have the PPOC, or Children's IT, that covers probably 75% of that security risk assessment. But that still requires you to have to go through and look at your security risk assessment and then create your risk management plan. Your risk management plan are those to-dos that you need to knock off to show that you're doing something. Do you have to do them all in one fell swoop? No. You just need to be showing that you're making progress, that you're in a defensible position if something happens in a case of a breach. Now, again, IT related, you're pretty buttoned up. We go into our practices. What's great for us is because when I sit down with your colleagues in some of your locations, I know what I get, but I still talk to the people at Children's in terms of what they're doing, how they're helping you folks access information, how they're going in and doing the audits of your systems to make sure that people are staying within their lanes. The second most thing behind IT-related breaches are individuals within your practice who, as I say, will let their personal curiosity outweigh their professional decorum, which means is that they're going to go poking around and taking a look at information that they shouldn't be. And unless you determine that audit process, which the PPOC should be doing with you, then you have no way of being able to know how people are behaving within your practice, okay? Are your policies matching your workflows? We've been in live audits. We understand live audits. We go through those with our clients. We deal with the OCR on that. We deal with the law firms that come in, the forensic groups that come in if there's a big situation. What we're seeing now is just by having a book of templated policies and procedures is not enough. You've got to start creating operational workflows to those policies and procedures. If you have a workstation policy, okay, everybody has the process. There's not a practice that I go to that doesn't have these processes in place. You've got good policies and procedures, but you've got to be able to map those now into your HIPAA policies and procedures. You got to show what's happening in your location. Tell them, have your people understand that, because you're trying to create an understanding to those individuals in your organization that you run a culture that says, we're going to spell out to you what your responsibilities are when you sign off on a confidentiality agreement, when you sign off that on the human resource, the employee manual. We're going to monitor you what's going on by doing the audits. And if we find that something's out of place, then we're going to potentially sanction you within the disciplinary process of the practice. You have those things in place, and you're in a really good position to sort of say, yeah, we run a good compliance shop. We make sure that we have these things in place. But you got to make sure your people understand how those policies work. And again, most people know because it's spelled out to them typically in the human resource. But if not, you got to build those things in so they live both in your human resource manual and in your HIPAA manual. Is your staff comfortable with being able to discuss that? Now, we have not seen this happen yet, and for years we've heard that they're going to start doing walk-in audits. I don't believe it's going to happen anytime soon, but it's like in OSHA. If an OSHA inspector's in your building, they have the right to be able to ask your people, what do they do if? Where do you go if you needed to leave the building? Where's the exit point? Can you tell me how you're going to run, an emergency situation? In this situation, you don't have that overarching piece coming in, but your people need to understand what their responsibilities are around privacy and security. Okay? Any questions about any of that? Just some quick things to go through on the update with regards to HIPAA. So the second part of that I'm gonna get through here with you is just talking through some of the aspects that I have seen, as well as have gotten some inbounds from some of your colleagues who happen to be clients with us. So these bulleted points here, I'm going to talk through these. Now, as Leah had said to you, we've created a document, and I'm going to basically live off this document for the next couple of minutes talking to you. This is a sheet that is a 6-page sheet that kind of scripts out all the things that we pulled from the feds, from the state, in order to sort of give you some guidance on some of the things that you guys deal with on a day-to-day basis. The tricky part in some of these things, and as I go through this, I'll be describing it as HIPAA, and then I'll be describing it as the state. And there's sometimes there's a rub, but the thing you have to understand, when there is a particular scenario where the state has their jurisdiction and well-defined elements around consent or confidentiality, state rules, okay? Not that HIPAA is damned, because not all states necessarily go into the depth with some of these things around medical record release, consents, when somebody turns into a mature minor, all these types of things. So I want to make sure that I have the HIPAA things in there, and we'll talk about the state things as well. And if anybody has any questions through this, please throw them out to me at that time, because we can get through that. And anybody who's also in your off-site locations. So medical releases. One of the questions that we had is, when a patient leaves the practice, do we send only office notes, or can we include records sent to us from previous practices, specialists or hospital documents as well? The answer to this is that a standard release of record applies only to those records which your practice has created. You can include an option for release of any or all records in your possession, even with those that aren't created by your group, but you only have the obligation to send those records that were created within your practice. Otherwise, all records not created in your practice should be released by the originating facility, okay? So you get an individual who comes into your practice, they're coming from out of state, records came with you, those records flow in. You should do a fairly good vetting of that to sort of move what you need into your medical record systems for that. But from that point forward, anything that gets produced from that individual now that they're under your care is what you only have for an obligation to release to. You can go through the other options of being able to do that, but if you, it becomes how much you want to sort of stand in the way of being a good citizen to work with your families and your patients to get information out there. Some people have a hard and fast rule that says, no, we're only going to send our information and that's it. No problem. Some others are a little more flexible in regards to that. Okay. What are the sensitive areas that require additional authorization? The sensitive areas that you would have to have additional information. So if you were sending information out, these are the items that you would have to redact unless you had additional authorization for these. Anything that had to do with sexually transmitted diseases, HIV/AIDS, genetic information, treatment of alcohol or drug abuse, mental health, and then psychotherapy notes, which includes behavioral elements as well. So, okay, any questions about that? Yes, ma'am.
We have a separation in EPIC for what our behavioral health specialists do, but our pediatricians and pediatric nurse practitioners are also now discussing a lot of issues related to anxiety, depression, all of those things in their regular office visits. But I guess maybe how specific do we have to get as far as not including the behavioral health notes in those releases?
So just for those people off site, the question was, is that the behavioral health, EPIC has you guys set up, and God love all of you for having to switch to EPIC over the last year and a half or 2 years. And the behavioral health elements are separated off, is that what I'm hearing? In a separate area for the behavioral specialists to be able to utilize. But there's more activity that's happening within the nurses and the physicians talking about behavioral health. It really becomes a question about talking to your behavioral specialist about where that sort of fine line is, because if there are things that you don't want to have part of that medical record, you really should have those being part, although the concern there is those people may not have access into those notes depending upon what their access is. So if there are things that people are documenting that are around behavioral, they just have to be very clear on where that sort of dividing line is. I don't have any examples for you per se, but you can also, if you're setting that information, you can also redact that information if you believe that to the extent of it, it meets the threshold of psychotherapy notes as well. Okay. All right. Next question here is what to do about parents requesting charts office notes for children 13 and up with sensitive information concerns. Now, the answer I'm going to give to you, this is a question that lives on the HIPAA site. And so this is the HIPAA answer. Regardless of applicable state laws, if a covered entity has reasonable belief that the personal representative, and in the case of personal representative on HIPAA side, a personal representative definition is a person authorized under state or applicable law to act on behalf of the individual in making health care related decisions. So that's personal representative is what is sort of synonymous with guardian or legal guardian in Massachusetts, okay? So just for clarification on there. But in essence, what this is saying to you is that HIPAA regulations permit that the covered entity to provide or deny access to records as long as the decision is made by the licensed healthcare professional and exercising a professional judgment. This is where redacting portions of the record comes into play in the best interest of the child. That quote is probably the most paramount thing that you have to think about when it comes to the notion of consent. As you all know, in Massachusetts at 13, if the doctor feels as though there's an individual that can make a decision, competent decision about their health care, they'll let them do that. If there's obviously circumstances where there's some kind of potential of injury, or there's to themselves or others, or if they feel like there's an emergency situation, they can overrule that. But in this particular case, this is where you take each case individually and you talk, and it really becomes the responsibility of your docs. Sit down with the docs and go through this. And if you have questions, as we were going through these questions, I was talking to my VP of compliance, she came from a world where she was a chief compliance officer. And she said, it's so gray that you have to take each individual situation and walk through it to understand the nuances to that. And if you have a question, then always bring it back to your compliance officer. Not that I'm going to sort of spoil Leah's homework, but the compliance officer needs to be identified in your practices. And more than likely, I'm going to blow it, Leah, I can hear myself, you guys are the compliance officers. If you have questions that you think need to be sort of pitched over, pitch them to Leah or Anna or the PPOC. A lot of times, I mean, again, you can use us as a resource too. There's those vagaries that come up, and you just have to be in a situation where if you're sort of going, okay, what do I do with this? Talk it through with your physicians. Your physicians become that point of resource of the most, they're the ones, they're typically the ones who are partners in the practice, but got to do it in the best interest of that child. All right. I don't have any particular examples to walk you through, just in terms of timeline. We didn't have that type of information. What do we do in a chart to determine who has legal custody or rights to medical records and information with divorced parents? So there's two types of custody. There's legal custody, which is where the parent who has been given the right and responsibility by law to make major decisions regarding the child's welfare, including health care. In that capacity, there's a sole legal custody and there's shared legal custody. And then there's physical custody, refers to where a child lives after divorce or separation. Physical custody does not always mean legal custody. Medical practices should request it and keep on file and updated as often as every year the latest court-ordered referencing legal custody of the minor. The couple practices that we had, some held to this pretty good. Others were not as good about being able to have that understanding. If you really want to make it simple for your practices, get that legal documentation. You have the right as a practice to understand where that is. And I'm sure that from a custody perspective, from your folks who are treating folks, taking the inbound calls, that they're constantly besieged by sort of issues that sort of have to deal, because it's easy for somebody to call in and say, well, here's my situation, but they need to understand where the custody resides, where that information should go. If the parent cannot show a proof of custody, consent and record release should not be accepted. I know that's hard sometimes. Your folks struggle with that, but that's the hard and fast elements of the custody items. All right. What circumstance do we release medical records without a signed release? TPO, which is short for treatment payment operations. It's part of one of the exceptions for authorization with regards to HIPAA. When HIPAA was created, it wasn't created to try to sort of to bend the care of individuals to HIPAA's will. They realized that they still needed to make sure that continuity of care flowed and was done. So provider to provider scenarios, covered entity to covered entity scenarios, treatment patient and operations, those are areas where you can release those medical records without having to get authorization for those. All right. The last question as it relates to medical records is, does HIPAA privacy rule allow parents the right to see their child's medical records? This is HIPAA. Yes, the privacy rule generally allows the parents to have access to medical records about his or her child or his or her minor's personal representative when such access is not inconsistent with state or other law. All right, so there's the vagaries again here. HIPAA is saying this is what we allow, but you got to go back to your state scenarios. And it's actually interesting because some of the state scenarios that relate to what HIPAA has, the exceptions are very similar to what's in Massachusetts. When a minor is the one who's consented to care, and the doc has signed off on that individual's ability to be able to do that. When the minor obtains care at a direct or a court or a person appointed by the court, we'll talk a little bit about that more in the DCF stuff. Or when, to the extent that a parent agrees that the minor and the healthcare provider may have a confidential relationship. All right. A lot of language here. The subtleties can be there. We'll talk a little bit more about the adolescent consent in a few minutes. So those are some of the things that we talked about and got inbound from your colleagues around medical record release. Probably tons of questions out there. I know I've got some time to answer some questions. How am I doing time-wise?
You're great. We actually do have a question from one of the other offices.
Okay.
So do they want to chat it in, or are they going to ask it out loud? Sorry.
Yeah, we have here in Bridgewater.
Oh, great. We can hear you.
Larry, go ahead.
Hi, this is Larry Duchess from Plymouth Pediatric Associates. And we recently had a situation where a child was brought in by her mother, and the child had some bruising. And she had recently been with her father. And so the mother brought that to the attention of the physician. And the physician reported it to DCF. And then the father wanted to find out from us what the mother said, and did the mother say anything in terms of the child and the bruising. And we said that we could not give him the medical record because it was in DCF investigation. So DCF did an investigation, and the investigation found that the abuse was unsupported. And so now we're in a place where the abuse was unsupported, and the dad is coming back in and he's saying, I want to see the medical record, because he wants to see what the mom said, because they're going through a divorce. So we've been saying that the information that the mom gave to the physician, and this is the physician determining this, was sensitive information and wasn't information that she was comfortable sharing, because it puts the mom in a compromised place, and she's intimidated by the dad and didn't want him to be coming back after her because of something that was said in the medical record. Now that the investigation is over, the dad wants to see the record. Where do we stand in terms of not giving him the medical record related to the conversation that the mom had with the doctor?
Who has legal custody of the child?
They both do at this time.
So it's shared?
Yes.
This is one of those really tricky scenarios that goes back to the element that I was talking in the best interest of the child. Now, granted, DCF has made their ruling to the extent of them not substantiating the physical side of this, but the practice, I think, this comes one of those scenarios where you may want to talk to a lawyer, because the legalities of this are a little nuanced, that to the extent that, to me, the practice should not do anything that's going to interfere with the divorce case. And although the father may say that he has rights to that record, that information can be redacted, because it doesn't really have to do with the child's care. But these are the things that you guys end up dealing with, that sort of end up having a lot of the things that you have to look at. But again, if this has the potential of being in a situation where it has compromised the child, then that information should be redacted. And this is really a hard scenario, but a lot of times we have to punt back to the practices, talk to the lawyer on that, or talk to The one thing I never quite know about you guys is if you have a DCF representative that you can go to these, that you can have these questions related to about.
We spoke with DCF and basically they said that we had no right to give up any information while there was an investigation. We have talked to our lawyer and talked about this in a specific case. Can you say a little bit about, I see the bottom bullet is about documenting sensitive information. So we have put some items under the sensitive category in the record. When somebody requests a record, do we have to include the quote unquote sensitive information?
No.
Okay. So if it's identified as sensitive information, then that's not information we need to share with the parent.
That's correct.
Okay, wonderful. Thank you. Very helpful.
Okay. Any other questions? Yes, ma'am.
It's a generic question, but you said if you know a couple is divorced or in divorce proceedings, we should ask for documentation showing legal custody. Our practice is fairly large, but it's in a small town, so does the information about a divorce need to come from a parent, or can it be through office gossip? I have nurses whose kids go to school with the patients sitting in the waiting room. So if I've got a nurse or somebody in my back office that says, "Oh my God, you should see them. They screaming at each other in the parking lot of the school," but yet mom has come in when they register their patient. Mom and dad are both listed. Mom has never said anything about a divorce. How can I ask for legal documentation based on office or town gossip?
I think a lot of it has to do with, you're not, when they're filling out information to the extent of their child, there's nothing on there that sort of says, our parents married, separated, or divorced.
It is on the family history. If you're taking a family history, our nurses or our doctors will say, what is the family?
But it's not being freely given to you voluntarily by the family. You're hearing it through a secondary source.
I've always operated on the information should come from the parent or the grandparent who's rated.
I think, your obligation is to go back to the family. If you're hearing this through a secondary source, your obligation is to go back to whoever the individual that you have the most interaction with and ask them. Look, divorces have a myriad of different colors, and all of you probably have sat and seen these things play out in your practices. Go back to the individuals and get them to support the information that you're hearing from a secondary source.
With that said, if unless there's documentation otherwise, you just assume both parents have equal rights. Is that what you would do if they weren't coming and saying otherwise?
If they weren't providing you the set that they were divorced?
Well, even if they are divorced.
Right. Even if
you can't assume that one has legal custody.
Unless
they have to produce that documentation that says who did the court give the responsibility to in terms of making decisions around the children. Yes, ma'am.
What if you have a situation where the one parent says, "I don't want you to tell the other parent anything in the record," or do you withhold it, or do you say, "No, we can't withhold it if he or she has legal custody"?
It becomes the doc's decision on if the nature of that information is sensitive enough that is in care of it. But if it's a parent on parent thing, I don't believe that would have to be. I would have to check on that one, but I don't believe. Wix, do you know in terms of your medical release stuff that there's a parent on parent information that?
I'm not sure. I'd have to check.
Yeah. See, there's vagaries that we'd have to look at, but if it doesn't have anything to do with the child's care and it's a parent saying to another parent that I don't want them to know about that, that should not be part of the medical record.
I think we have another question. Oh, we don't? Oh, sorry. Never mind.
Okay. How am I doing time-wise? Because I got some.
12:52.
What is it?
12:52.
Oh, you're doing fine.
All right, so what I wanted to get through here is a couple more things. Age 18, just some quick things about that, because in Massachusetts, age 18 is the age of maturity, and therefore, once the child reaches 18, unless extenuating circumstances such as legal guardianship exists, the patient becomes responsible for their treatment and payment for all services. So when you're dealing with 18-year-olds, my kids are a little bit beyond that, you have to kind of sort of give them, I would say, the thing that you want to do is sit down with the 18-year-old and tell them what their responsibilities are now that they are deemed a mature adult. So they should sign their own HIPAA information. Yes.
Are you suggesting that you make them their own guarantor immediately at 18
Yes.
without their consent?
Without their consent?
Without a parent's consent, without their consent?
They're 18. They can make that. You should have that ability to sit down and let them know that as an 18-year-old and as a mature adult, they have certain responsibilities under HIPAA now.
Right, but I'm just saying, we don't arbitrarily, just as soon as their 18th birthday comes, we change it right to their own guarantor. Is that something everybody does? I don't believe that's the
No,
these
these are things that you want to do.
Most 18-year-olds are not going to pay their bill.
Well, yes, and I've got a comment here that says if the 18-year-old didn't want that information to go to their parents, then they would have to foot the bill. Never going to happen.
Right.
So, so parents can get the information from the insurance. Kids just, whatever you can, goes around, whatever you can do to make the 18-year-old aware of what their responsibilities are. No, you don't have to sort of go right to that. But let the 18-year-old be aware of, look, you've got obligations.
I'm trying to think if an 18-year-old is going to a pediatrician, then they're probably not interested in being on their own and paying their own bills.
Yeah, I mean, again, I don't know. I know because now kids can go to 26 and be on their parents' plan, that sometimes people just stay with their pediatrician to 26, I've heard. But your point is a good one, is that typically at that point, maybe they should be moving. I mean, in most cases, and not to single out women, but most of the times, the ladies are moved to an OBGYN or a different situation as their primary care sometimes. So, but there are people, I mean, I know that there are kids that are 18 or older that are in your practices, yes? Yes. So, all right. Adolescent treatment. Mass law sets forward a list of conditions by which a minor by law is considered emancipated. Therefore, they may consent to confidential health care on his or her own. Mass courts have adopted the mature minor rule against everything except abortions and sterilization. This rule says that if a doc believes, this is straight out of mass law, the minor is mature enough and able to give informed consent to medical care, it is in the best interest of the minor not to notify the parents. The physician may accept the child's consent alone. Now, the law also has special provisions around drug addiction, family planning services, treatment of sexually transmitted medical health. So under drug addiction, if 12 are over and certified to be drug dependent, may consent to appropriate medical care. Family planning. Sexual active minors of childbearing age may access family planning services offered through the Department of Public Health without the consent of parent or guardian. Sexually transmitted diseases. A minor who reasonably believes he or she is suffering from or has been exposed to a disease classified as dangerous to public health may seek treatment for that disease without consent. Minors who are 16 or older may consent to admission to a mental health treatment facility. In an abortion, a minor who is married, divorced, or widowed can obtain an abortion without the consent of a parent or a guardian. Otherwise, she may seek parental consent or the consent of a judge of the Supreme Court. Exceptions to that: emergency care does not require parent or guardian consent. Alcohol abuse, if the minor is intoxicated and applies for treatment to a detoxification facility or is brought to a facility, the minor may receive treatment at the facility, except that he or she may be released to the parent or guardian. Again, don't worry about these. These are all going to be within the context of a document that you guys can look at and use as a reference point. And again, with any other questions, we always will leave ourselves open to be able to give you guys an option to call on us. All right, DCF custody. So yes.
Can I ask another question about the adolescents? Is there any way to make it so that the insurance company cannot send their parents an explanation of benefits that tells everything they had done? Because the law says they can make these decisions, they can have all these things done, but there's no way I can keep the EOB currently from going to their parents and then I get the call.
Not that I'm aware of.
They have to self-pay if they don't want.
Yeah.
Their parents
Can I address that?
Sure.
If you have a particular lab that you usually send those chlamydia screenings to or other tests, we did this in our practice and the lab changed how they explained what the testing was so that that did not show up on the EOB. I'm sorry, I don't know the rest.
Oh no, it was me. We're having that trouble with birth control because now your EOB says all the medications you're currently prescribed right on it, if it's like carbidopa or one of those.
Mm-hmm.
So it's like they can make these decisions, but they really can't keep it from their parents if they don't take them.
I can take a look to see if there's something that's precedented, but I've not at this point. I mean, if they get that information, yes.
Can you just repeat the question quickly? So
the question was that, is there a way that to hold back information that comes from the insurance company around sensitive, confidential information? That was the question.
Birth control, those types of
The
things.
biggest concern on this had to do with birth control because obviously if that information is coming through on the EOB, the medications are going to be there. Certainly someone can look at the medications and realize that it's for birth control. So now you've kind of lost that sensitivity or you've lost that sort of ability to protect the child's consent against that. And I'm not aware of anything. The only way that could happen at this point is if the child ends up footing the bill for the services. And then they have the ability to be able to not have that information go to the parent. I can, it's an interesting question that I'll poke around on and take a look at to see if there's anything out there. So.
Because even when they call the insurance company about a claim, they'll say, well, like, what was the diagnosis on that visit? And they'll give them chlamydia. They're not keeping it safe when you call to discuss it. Like, and those visits are now hitting everyone's deductible. So mom and dad are calling and going, well, what was that visit for?
So Nicole from Patient Safety just chatted in and she said she'll send out some information about the PATCH Act, which is an act to allow patients to have EOB sent directly to them rather than their parents.
Oh,
so she'll share that.
Great.
Cool.
Thank you.
Okay. Got a couple more minutes here. Wanted to go through some things that are related to DCF. So the DCF has two types of custody. They have the CRA, which is the Child Required Assistance, which may also you may also have heard as CHINS. Used to be the old acronym for it, which was Children in Need of Services. This is shared custody between the DCF and the parent. So one that's sort of the least egregious that they want to get into. But after talking with somebody who works with the DCF, most times the scenarios that play through from a custody perspective are what's called C&P, which is care and protection. And DCF takes control via court order of all transactions that have to do with medical care. And the nuance on that is that if an individual is receiving routine medical care, then that information can transpire between DCF and the practice. If it ends up being what's called extraordinary care, in that situation, DCF has an obligation to appoint what's called a guardian ad litem, which is an individual who is now in a court-ordered place to be able to make decisions, major decisions. And in the documentation here, I've got some information that deals with what's routine and what's extraordinary. So, and as I learned from talking to this individual, DCF says to HIPAA. People who didn't see that, I did an Italian version of saying they don't abide by the rules of HIPAA, which is very interesting from our perspective in compliance, because even those groups that are associated with DCF as additional services, and each region has a component of that, they have to live by they have to live by the HIPAA rules. So they can't do all those things that your organizations have to do in maintaining and safeguard privacy. But DCF, they're a government agency. They kind of say, he's received documentation from DCF, 50 pages of notes and information as it relates to the child, not only to the personal side, but to the medical side. And they just sent it right over standard, email. So, if you've got information that doesn't provide, if you're interacting with DCF, maintain your queue and maintain your compliance around. Just because DCF doesn't have to do that doesn't mean that you're off the hook. You still have to take whatever mode necessary when you're passing information back and forth through DCF, that you've got to do what's important, whether that's through encrypted email or sending that out through, a carrier or, however that may transpire. Okay. The question?
A question from Northampton. Can you unmute yourself, Northampton? Is it a chat or is it an actual question? Northampton, do you have a question about that? DCF custody?
Sorry about that. Go ahead, Lynn. Yep.
Hi, this is Lynn Mackin from Pediatric Care Associates. Last week, we had one of our 7-year-old patients go into DCF custody, and they had to come into the office to be seen. It was a question of sexual abuse. So labs were done, and there wasn't a court date until Friday. So Friday morning, mom calls and wants to know why she cannot see lab test results via MyChart. The reason that she couldn't was because when DCF brought the child in, we had changed the guarantor to DCF. And so my question is, did mom have a right to know?
Once that's transferred, if that individual, in my understanding, if they've gone under what DCF's called care and protection, then DCF becomes the authorizing body. And that parent is no longer able to get information.
Thank you very much.
If it fell into a situation where the custody was child required assistance, where it's shared, then DCF oftentimes tries to recommend that the parent, promotes the decision making. But it sounds like in this case it was probably a C&P. So all bets are off for the parent getting any information at this point.
Thank you, Lynn.
Okay. What medical treatments are considered routine? Instead of going through this, because I want to give WIC some time to go through the compliance plan, I've got this on this sheet. This information was from a tremendous source. And as I was speaking with this individual who has worked for both DCF at one point in his life and also for a servicing agency, he had said to me, if there's ever, interesting nuanced questions that come out from a DCF, to send them to me, and he'll run them up his connections to DCF. He said that DCF is a very insular organization, and sometimes they hold things very close to the chest. So, but again, I know that there's some custody issues that come along with that you folks end up dealing with. But if you got questions, again, we can be a resource and try to get those answers for you. Okay? Any other questions before I turn this over to my colleague?
I think there's one more slide. I don't know if it's yours.
Let me see here. Do I have one more? Yes, preparing your staff. I can't say enough about being in a situation where your organizations are doing what's necessary to keep your staff trained. Probably for you folks, it feels like an endless battle. You're dealing with training that has to deal with clinical information. You're dealing with information that has to deal with HIPAA. You're dealing with all these sort of nuances that we've just talked about here, but you got to do it. Your folks need to understand that, and you need to be in a situation where if you're holding whatever meetings that you've got on a monthly basis, bring these things in, sprinkle them about, keep it up to, keep them top in their heads. Open up your forums. The greatest learning for me, because a lot of my learning has actually come from you folks, because we get a question that comes inbound from one of our groups, and it's not coming from the practice administrator, it's coming from someone within the staff who's just kind of scratching their head because they just don't know. So if we can facilitate in a way to provide you the data points that you can bring back out to your teams, take advantage of that. But training is one of those essential things. It's paramount for you to be able to keep these things top of mind so that you know that your staff is doing the right thing. And you need to be in a situation where you're comfortable, and I'm sure this is all the case, that you keep yourselves available under an open door policy so people know that they have access to you or your docs or your supervisors. Because if people don't feel comfortable by using your hierarchy, that sometimes smells, and I'm going to sort of leave this as a lead in to Wix's compliance stuff, it sometimes leaves the door open for people to do things that you don't want them to do, that have some other ramifications that may play out in a different way with regards to whistleblower, which may play out with regards to being disgruntled about whatever. So keep things in your folks' heads, work with them on that, be open to hear what they're saying. I know your jobs are difficult because you juggle a lot of balls, but your employees are your front lines, and you got to make sure that they understand what's happening.
We have a question in the chat.
Okay.
Okay, one more question. Is the practice allowed to ask DCF if the case is shared custody with the parent or care and protection?
Sure. I mean, you got to know. You have to know what circumstances you're dealing with, if it's going to be a child required assistance or if it's going to be a C&P. So absolutely. Thank you all for your time. I appreciate that.
Thank you, Todd.
I turn you over to my colleague, Mr. Wix Moffat.
And really quickly, it was brought up once, my chart, there's confidentiality training available. If you go to Learning at PPOC platform, you can search my chart. There's multiple tip sheets out there on how to deal with confidentiality on my chart. So I just wanted to bring your attention to that. Thank you. And now we'll move on to the compliance plan. Thank you.
Hello, everybody. Glad you could make it out here on a rainy afternoon talking about compliance. Probably not the best combination ever in the world, but here we are. Let's just dive right into this. Just by way of quick background, I've worked with Mike and Todd and Healthcare Compliance Network for over 20 years. been in thousands of physician practices. Can't tell you exactly how many pediatric practices, but a lot within those thousands. So we've gotten to see a lot of stuff out in the field. And I prefer, as I go along, if people have questions, just like Todd, no need to wait till the end. Kind of jump right into it. And when we were pulling together this presentation, I got a lot of grief for this slide, and understandably so. First of all, it's not laid out very well. Secondly, well, I'll just read it because it's probably hard to read. Of all the people in history that have reached 65 years of age, half of them are living right now. And it would probably be very well accepted. And if any of you guys said, well, he's at a pediatric lecture. Why is he talking about people over 60? That's the exact opposite end of our spectrum. And I'm going to pull it all together in a second as to why I bring this up. One reason is I just kind of like weird little factoids, and it came from the internet, so I'm sure it's 100% true, just so you all know. But you may want to fact check it. At any rate, I think one of the things to point out to set the table a little bit for today is healthcare is a big deal in this country. Probably a big deal worldwide, but in this country, it's a big deal. Everybody knows probably somebody that's getting some healthcare right now. It could be yourself, could be a loved one, could be a neighbor, could be a friend, whatever. And it brings up a lot of concern. One of the first concerns is quality. When you go for healthcare, or your child does, or your mother does, or whatever, the first thing you say, oh man, I hope they do a good job. I hope they know what they're doing. I hope they can provide quality. And very close second, sometimes it might be first, is how the heck are we gonna pay for this? Healthcare has become very expensive. It's definitely, I would say, one of the 3 hottest topics in politics right now. I mean, the economy is maybe number 1, but healthcare is tied into that because it's 20% of our GNP. I don't know what the others are. There's a lot of noise out there, but day in, day out, it's things that people are constantly thinking about. And let me ask the question of the group here. How many people in this room, and I can't tell remotely, but I'll probably get a good cross-section, how many accept Medicaid or have Medicaid patients? Okay, most of you. And I know in the more affluent areas, in your Duxbury's and your Westons and things like that, maybe you don't have a Medicaid population. But if you're accepting Medicaid, you need a compliance program. It's called a condition of participation. I can show you the CFR and all of that. So for those of you that didn't raise your hand and you do not take any Medicaid, unfortunately, you are not off the hook either, because all of the commercial payers. So unless all you do is accept cash at the window, you don't have any insurance, which I guarantee you isn't any of you guys, then you don't need to have a compliance plan. I would even still argue in that case you probably should, but so everybody needs a compliance plan, and I'll show that. One of the things I like to do is, because I believe in this room, if I understand my audience, all of you are administrators, office managers, not necessarily the doctors. Are there any doctors in the room? Couple, okay. Regardless, most of you, if you don't have a compliance program, or you need one, or you have one that needs to be buffed up and updated a little bit, a lot of times you bring it back and you may have to talk to the doctors or your partners or whatever the case may be. And oftentimes, I've been doing this long enough, you get them saying, come on, that's for Mass General, that's for Lifespan, that's for, Partners of the World. And by the way, I'm not sure what's going on up here. They may all be the same organization at this point, the way everybody's consolidating. But you get a lot of saying, my small to mid-sized pediatric practice, why do we need to worry about this? And I like to present, and everybody's going to have access to this presentation, right, Leah? I think you send it off to everybody. It gives you a little bit of ammunition. Say, hey, look, I'm not making this stuff up. I'm not trying to be a pain in the neck here. this is what we need to do. You guys make an informed decision as to what you want to do. So I know there's a little bit of a selling job, for lack of better words, that sometimes you need to do to get people to kind of buy into compliance, figuratively and monetarily as well. I always like to show this slide because it's the healthcare oversight agency. There are so many regulatory agencies, unfortunately, that you guys have to comply with. We used to work with the gentleman by the name of Michael Putnam, who worked for the Attorney General up here way back in the day under Scott Hirschberger, I think was his name. And he used to say, you could open up a nuclear power plant. You can open up a pediatric practice. A pediatric practice actually has more regulatory oversight than a nuclear power plant. So, congratulations, you're in good shape. Obviously, we're not going to go through all of these organizations, and some of them might not be relevant to you. The first couple is CMS, Office for Civil Rights, which Todd just talked about. That, in case you don't know, that's sort of the police for HIPAA. And I just put payers, your Uniteds, your Aetnas, your Blues, all of that. So these are all people that have oversight and are looking at you to make sure that you're compliant with whatever regulations they may be throwing at you. So it gets complicated. How did we get here? I always like to follow the money. As I mentioned before, and I'll show another slide in a second, there's a lot of money in healthcare right now. It's expensive, even personally. I mean, I don't mind saying this. I mean, now for just my wife and I, we spend close to $2,000 a month. Each of our deductibles are like $5,000. I'm like, that's like $35,000 before anything even gets paid for. That's a big number to 90% of the people, unless you're a 1% or whatever. That's a number. It makes you think. And I think it's why it's on the forefront of pretty much everybody's mind. And to what I just said, the public is just really more dialed in on what's being spent. Well, you guys see it every day, I'm sure. What do you mean where there's a deductible? What do you mean that, this is what we owe? The whole thing. But under the category of follow the money, it has become a very lucrative pursuit for the payers. And when I say payers, I mean CMS and your commercial payers. For the last, I know Mike's in the room somewhere, but we always monitor this stat every year. And for the last 15 years, we've seen it as low as $4. For every dollar that CMS spends, they get $4 to $13 back. That's a pretty good, I mean, even if it was $2 for every dollar they spent, they're doubling there. So yeah, they're out to make sure that you're providing the quality that you're supposed to be for their members or their clients, which are your patients. But let's face it, it's also bringing a lot of money for them. It's making money for them. And here, I think this is maybe the most interesting thing, and I'll talk about it for a second. Commercial payers don't publish stats on this, but they answer to shareholders, and they are in it to make money. I mean, look at United and Optum. I mean, it's like one of the biggest companies in the country right now. I mean, Apple's bigger or whatever, but they're certainly in the top 20. And yeah, they have boards of directors and shareholders to answer to. And what do boards of directors and shareholders do? They have fiduciary responsibility to make sure that their company is making money. Now, I'm not trying to paint them as villains. I'm just showing you or letting you know that's the real world. They need to make money. Again, not saying they don't even provide a good service. It's just the reality of it. And they don't publish stats on this. And I have a feeling the reason they don't is because it's a lot. And I'll give you a quick stat as well. And this is just a stat from HCN, actually. 3 years ago, we had 8 of our clients that were being audited by commercial payers. Yesterday, I looked at our database, and we now have 113. That's quite a big increase. There's probably reasons to explain it, but there's no question that they're doing what CMS has done. They're like, well, CMS is making pretty good money on this. We should go out and check too. They also do have, and I'll keep using the fancy word, the fiduciary responsibility to make sure that the quality of care is being delivered. That if you're paying for a service, that it's actually being performed and delivered, and that you're documenting it right and coding it right and billing it right and all that stuff. We'll get into that in a little bit. But just a couple stats there. In 2020, healthcare is supposed to be $4.64 trillion. I don't even know. I have no idea what that kind of number is, but it's big. 20% of our GMP, which I've already mentioned. So people always ask me, how can I prevent an audit? And the answer is, you may not like this answer, there is no way to prevent an audit. You can do a lot of things that can put you in a defendable position. You can have what are called safe harbors, and I'm going to go through those elements with you so you all have a takeaway. If you decide to build this yourself or audit the program you have, it's kind of accepted best practices in our compliance geek industry that people go off of, and certainly the OIG, Office of the Inspector General, has recognized it. Oh, I wanted to show this. I mentioned to you that I like you all to have some ammunition to bring back to your partners or your doctors or your board of directors, whoever it is, that say, well, you know, the commercial pay, I mean, who cares about them? Well, this is directly from United Healthcare. How many in here accept United Healthcare? But pretty much everybody, right? Almost, you know. And by the way, Blue Cross has the same one. Cigna has the same one. And these happen to be 7 different elements that they outline as to what you need to have in your program. And when you sign the contract with them, you've signed what's called a condition of participation. It's a fancy way of saying you better be doing this. Because if we audit you and you're not, you really don't have anything to stand behind or defend yourself with. So let's get into, it's commonly called the 7 elements of compliance. First of all, does anyone have any questions up to this point? Because now we're going to get into some of kind of the nuts and bolts of compliance. I'm an acronym guy, and I know in healthcare we all have way too many acronyms that we deal with on a daily basis. But I actually did this so I could help remember what the 7 elements of compliance are, and it's kind of emblazed in my brain at this point. But does anybody know what any of the 7 elements of compliance are? I'll give you a clue. I gave you the initials. Okay. Good. So that means this seminar might actually be worthwhile. Here we go. Number 1, implement written policies and procedures. Designate a compliance officer. Educate your people. Todd mentioned that earlier. Respond. Do an audit. Develop effective lines of communication and enforce it. Each single one of these actually tie in with each other, and they are pretty important. And again, if you are building a compliance program, or maybe you built one years ago and say, let's dust it off and see where we're at, this is a really good and accepted practice to go off of to measure how you're doing. And compliance is kind of weird. You know, you could, let's say you do this and you spend the next 6 months pulling together your program. Say, oh, great, I'm done. Unfortunately, you're never done. It's always ongoing in the auditing and things like that.
I have a very basic question.
Sure.
Is this all about fraud, or what are we actually talking about? Whether you code improperly or whether someone is trying to steal, what are we really talking?
So that's a great question. My definition of a great question is one I can actually answer. So that's a great question. I think I can answer it. That's yes to kind of all of the above. Fraud is one of them. I mean, you know, billing for things that you didn't do. Very basic stuff you guys know about. You know, saying you did an appendectomy when all you did was look at poison ivy. It's a crazy example, but you get the point. Stealing, certainly. Stealing drugs, stealing money, stealing co-pays, stealing it. We had an example down in the Philadelphia area. One of the pharma reps was getting access that they had like 6 locations. Like, why is this pharma rep getting all the access? Well, he was giving Eagles and Phillies tickets to the 2 people up front and getting access to come in the back and leave the sandwiches, and was basically breaking every rule in the book. And that's the Sunshine Act, which I won't get into right now. But yeah, it's having a code of conduct and code of ethics, and we're actually going to get into some of that. So hopefully I'll answer your question in a little bit more detail. So one of the first things is implementing your program. And really, if you know anything about the government, any time you're going to implement a program, you need to write up policies and procedures and manuals and compliance forms and all of that. This seminar today isn't really quite deep enough to get into all of that. But what we are going to do at the end of it, Leah, is I'm going to give you a table of contents of what a compliance manual looks like. So you'll see that it's, 167 pages. It talks about enforcement. It talks about hiring. It talks about firing. It talks about billing. It talks about audit. It talks about all that stuff. So it'll give you kind of a little bit of a guideline to run on as to what is actually in a compliance plan. So the next step is appointing a compliance officer. Implementing your program and appointing a compliance officer arguably kind of go together. But let's talk about that for a second. How many of you in this room are the compliance officer for your practice? Okay, a couple. How many, well, you may not want to answer this question. If you don't have to raise your hand. How many don't have a compliance officer? Okay, that's fine. You're not alone. It's not unusual. So I'm glad you came to this seminar. So how many of you have a compliance officer that's outside of you? Okay. You do want to appoint a compliance officer. Somebody should be at the front of it. Now, a compliance officer is different for different organizations. A compliance officer at Mass General has, 40 people that work under her, along with IT, the whole thing. For a practice, depending upon your sizes, this is something we can give you some advice on. But in general, who they do not want to be the compliance officer is your attorney or the CFO. Someone that has access to the money and things like that. It should be someone that is kind of has authority in the practice, but is unbiased. Now, doctor, you may have a small practice. Okay, perfect. So we run into that all the time. We work with tons of practices, and yes, the doctor is going to be the compliance officer because the doctor is the only one that's going to be there. And if he or she is not there, then the practice isn't there. So that's fine. That's acceptable. But they do look at things like that if you are audited. In general, and a compliance committee. Now, again, you're probably going to snicker, doctor, because you're like, compliance committee, I mean, we've got 8 employees, or what are we going to have, a full 3 employees or whatever, 2. Gotcha. So you're probably not going to have a compliance committee. What you are going to want to do, though, is communicate with your 2 other staff, as small as it seems. Hey, look, if you see any problems here, or you notice any irregularities or billing, or you feel like the other employee is harassing you, and I'm sure it'll create some jokes, report it so we can take care of it. So yeah, it is, it's not unusual. We have a ton of clients in the New York City area, which is very, very common to be one doctor and one employee. So I do understand. So not one compliance program fits everybody, and that's something that we can talk to you about. But let's say, let me ask another question. How many practices in here have 5 or fewer doctors? Okay, half of you anyway. 6 to 25? Okay, over that? Okay, so it's kind of your standard spread. When you start getting into, you know, let's say 10 doctors and things, you know, you really do want to have a compliance committee. There is no regulation that says how often they need to meet and who should be on it, but generally you would want to have somebody that's good with IT or sort of your computer geek. You probably would want to have a nurse or a clinical type person to talk about things like OSHA and safety and, you know, bloodborne pathogens, infection control and things like that. You probably would want to have someone from billing and perhaps one of the doctors, because you want to have someone that can also make a decision, or the office manager. Okay, so if anybody has any additional questions on that, I'd be happy to answer them. But that's where it gets a little bit funky, because what may be right for one organization may not be right for the other one. So education, and I'm going to stop here for a second, because there's the 7 elements and they're all really important, but people always say, okay, I have so many things to do. I don't even know where to begin or what to do. If I just had to do like 1 or 2 things, if you had to pick out the most important ones, and compliance people might argue this back and forth. So my own personal opinion on that, if you do nothing else, put together your policies and procedures in your book, and then educate your employees. The other stuff, yep, absolutely should do, but those, if you're gonna do nothing else, at least do those 2 pieces, because now you've got a program and now you've got people. What happens is somebody may come to a seminar like this and they may get a fancy table of contents, and they might, you know, look at this PowerPoint and say, I'm gonna do this for the next 6 months. I'm gonna sit down and take it 1 step at a time and write it all down. Great, they got a great program, but nobody in the organization knows about it. If you got to make sure that everybody's educated. Typically the main reason people fall down during audits is because of employees and their lack of education, answering questions incorrectly, providing information maybe they shouldn't. So on education, couple things, like it really should go along with everything that we're talking about today. Anything you do with regards to compliance, if you have a compliance committee, document it. When you do your quarterly or twice a year meetings, document it. When you train employees, document it. In fact, you all should document that you came to a compliance seminar today. Maybe that's the beginning of your compliance program. Yep, we're being proactive. We, sent one of our employees, halfway across the state or wherever to sit in a compliance seminar because we are now committed to doing it. At least you're showing that you haven't swept it under the rug. So Leah, I'm assuming there's documentation that they showed up to a meeting today. Okay.
As long as you signed it.
Good stuff. Master of the obvious here, don't forget new hires. So training should be done annually. It should be done as regulations change. You don't need to worry about that as much as making sure you do it annually. And of course, new hires. Everybody should be trained. A lot of people say, oh, well, the doctors don't need training. Actually, that's probably the most important ones that should be trained. By far and away, the hardest ones to get to do the training, but the most important. So every volunteers, interns, essentially everybody should be trained. And I say you should do it annually. I've seen people do some creative things where they just do a compliance tip of the month, that's fine. At least it's an ongoing training type thing. And they'll go through, how do we release a medical record in this office? That's a compliance tip of the month. So there are other ways you can do it. You can be creative. So respond. This is probably the number one reason for an audit is, or at least if it's brought on by an employee, if an employee comes to you and says, look, Allison has been taking tickets for the Phillies and the Eagles for the last year and a half. It's really, I know that's wrong. Say, you know what, Allison's been the receptionist for the last 20 years. We're not going to ruffle her feathers. That's fine. You know, and you keep, and you don't respond to it. That's bad. People want to be heard if they communicate, and we'll get to the communication part in a second. If they communicate a complaint and you don't address it. But let's talk about how you respond to a letter or an on-site audit. Do any of you guys ever get letters from the insurance companies, or have you ever had someone show up for an on-site audit? Okay, that's good. Count yourself lucky. Let me tell you what not to do if you get a letter. Don't not respond. It's too many double negatives. If you get a letter, respond quickly, respond promptly, and respond with just what they are asking for. I'm also going to talk about who you should contact if you get a letter in a second, but we're seeing amongst our clientele a proliferation of letters for audits, and they'll say, hey, we realize that your E&M coding doesn't, the documentation doesn't support it, and it's higher than it should be, and we are going to do what's called extrapolate, which means we've noticed this pattern for the last 6 months. We are going to extrapolate that out 5 years. Please respond to this letter and or write us a check for $1 million. We have letters like this all day long. And at that point, there's a few things you're going to want to do. But number one, respond to them promptly. Be courteous. All the common sense stuff, but don't shove it under the carpet. We're seeing more on-site surprise audits too, where they just show up. In that case, and this is where you want to educate your employees, because somebody comes in with a badge or is an official from Blue Cross or whatever, and you're not on top of it, and they take them back to the EMR and let them start looking at stuff. That shouldn't happen. Your employees should be trained, if you do nothing else. If there's an on-site audit, say, hey, great to see you here. Please let me see your credentials. We would love to get you the information that you're looking for. Please let me know what it is. And Dr. Smith is seeing patients right now. Could you come back when she is available on Wednesday at 2 o'clock? We'll make an appointment. Usually they'll be like, okay, and they'll leave the information. I'm very skeptical of just letting them in and letting them see what, because then if they start seeing stuff they shouldn't see, it may not bode well for you. So I was mentioning, who do you contact if you get a letter? Well, I would think PPOC, right?
I have a question.
Oh, sure.
If it was an on-site audit, are you required to give them access to the EMR, or can you say what records and give them access to the records specifically that they're asking?
So the question for the remote group is, if there is an on-site audit, are you required to give them access to the EMR? And the rest of it was?
Or could you just ask which records and print out records?
Or could you just ask them which records and print out records? Answer to the first part, no, you are not required to give them access to the EMR. Right. And now, if they come in with a subpoena or something, then or a search warrant or whatever, then we're all having a whole different conversation, number one. But No, what you should do again is look at their credentials, find out what they're looking for, and you do not need to let them bust in and look at your EMR. Now, most of you in your contracts that you have signed does give them, most of them have a caveat in there that says they can look at your EMR and analyze various claims and charts and things like that. But you absolutely can put them off. Okay. And yeah, again, very important to ask exactly what they're looking for, because then what you would want to do instead of giving them access to your EMR is say, what are you looking for? Great. I will pull these records myself and put them in a secure data room, Dropbox, share file, whatever you call it, a HIPAA secure, and then they can have access to that. Okay. It gets a little complicated. So thanks, Leah, that's kind of a good segue into, so one of the first people you would want to contact, and I don't know that there's really an order, but perhaps PPOC, because they may have some other people here. You guys may have a law firm that helps represent you. You do hopefully have a compliance firm that will help walk you through that as well, HCN, and that's my only sales pitch I'll give. And your medical malpractice. Most of you, I don't know all of your medical malpractice policies that you guys have, but most of you embedded in your medical malpractice usually have anywhere from $25,000 to $50,000 of coverage for cyber, which is what Todd talked about, and for sometimes what they call error and omissions or billing. And that isn't to pay the fine, but it's to represent you to hopefully show your innocence. Most of our clients in these situations, we are paid by the insurance company to come in with the attorney and help mount a defense. Speaking of that, if you get a letter, I would tell you of the hundreds we've been through, only one or two, and we can generally tell pretty quickly, have we said, yep, they're right. The provider wasn't credentialed, or they were doing something egregious. Most cases, you never want to roll over. Never want to roll over. You want to defend yourself and explain. Now, they may still find out you're wrong, that you know, it didn't support a level 4, or the test wasn't medically necessary. I don't want to get too in too much detail here, but you still want to fight it. You still want to fight your case and negotiate it, because if you just roll over and say it was on consults or high-level E&M, guess what? They're going to come back in 6 months and start questioning your modifiers. So I'm a big fighter in these cases, and generally that's done with an attorney, a compliance company, and your medical malpractice. Okay. Next slide here. Audits. Well, first of all, you should probably, if you have a program, you should audit it to make sure that it's up to date, it's on track, it hits all the 7 elements, and you can do that against the table of contents we're going to show you. But audit here more specifically is auditing your billing or your chart, coding. You really want to do this typically 10 to 20 charts per provider. You can do it 2 ways that I know of. One is internally, and that's good. It's better than nothing. 2, and I don't want to give a shameless plug, but doing an external audit is sort of the fox not guarding the hen house. It's having a fresh set of eyes in there. And it also plays very favorably in the eyes of the regulators if you have somebody externally doing it. And there's a lot of organizations out there that do it. If they do it, or you do hire someone to do it, make sure that they have good credentials, make sure that they've been through these types of audits before, make sure that they defended clients and defended them well. There's kind of a lot that goes into it. Whoops. Uh-oh. I think I messed up here. Does that work? Now I'm on the mouse, which is a problem. Okay. Communicated. This is pretty quick. You should communicate to all of your employees, and you can do this verbally, but again, what do you want to do if you do it verbally? Document it. Next time you have a staff meeting, or if you have a small enough practice and you all meet in the break room, in the coffee room, say, look, we have a compliance program we're working on. If you see anything, please communicate it to us. We want to respond to it and make it very apparent. You may want to, once you appoint a compliance officer, formal as it may seem, you may want to put something even in your waiting room saying, Allison Smith is the compliance officer. If you see anything, report it to her. So you just want to let people know that there is a line of communication for that. There are lots of services out there that have hotlines and things like that as well. Enforcement. So all of this really, if you have a compliance program you've educated and then you find you have problems and you don't enforce it, that's not good. You can't do that. And we get this a lot, especially in smaller practices. And they say, you know what, this doctor, I mean, she is the rainmaker in this place. I mean, she's billing over $1.5 million a year, and you're saying that that she's billing incorrectly, or I saw her billing for procedures that she's not really doing. We're not going to enforce that. I mean, she's one of the owners, and again, the rainmaker, and that you have to somehow get around that, and you do have to enforce it. And I know that's kind of a hot potato, especially in the smaller and mid-sized practices. Audit trends of the years. Here's a disclaimer. I am not a certified professional coder, so if you guys start asking me detailed questions about some of these things, I'm probably going to have to tap out, but we do have people that can help answer them. These are the hot topics in pediatrics. These are what we're seeing throwing off the red flags, prompting letters and things like that. Developmental testing, ADHD, motor skills, neurology. We have a client right now who is having a problem because is it the Snellen test? Is that what it's called to see Snellen, right? Yep. It's to see if you have 20/20 vision or what your vision is. He had a group out of Florida that sold him a machine for eye testing, and the Snellen test gets him $8 from Medicaid. Well, this test that he did got him $204, and he was doing these tests way too often and not referring. Apparently, it's a great test. He's a very caring doctor. He thought he was doing the right thing, and he had been doing it for 3 years. His fine is over $1 million, and we're in the process of representing him right now. And again, good guy. It seemed like what he was doing was okay. And his defense, by the way, was, well, you didn't tell me for the last 3 years that I couldn't bill this. And that's not a defense, because they just pass through the bills and they do it on good faith. So take a look at that stuff. How to respond promptly and courteously. I already went through this a few slides ago. PPOC, practice attorney, med mal, compliance company. And that's it. 6 minutes ahead of time. Any questions from remote or local?
Sorry, I'm not like the questions. How do you tell the owners of your company, like, how would I record? Because I'm employed by them.
Yes.
Positions are above me. I mean, is like writing them up and being like, hey, you were naughty, please sign this to prove that I told you were naughty. Is that enough? Because my OSHA compliance guy came in and said, do you have insurance if you're the HIPAA compliance officer? Because you're going to be responsible for anything that goes wrong. And I was like, oh, great. Because we can try, just like we can tell our doctors, never leave your computer in your car. Like the poor Brigham and Women doctor,
right.
His computer in his car.
So the question was, first of all, if I'm the HIPAA compliance officer, or I'm the compliance officer, I mean, can I be held liable? Should I be getting some type of insurance for myself? First of all, I don't think there is any insurance for yourself.
That makes me feel better.
Yep. And secondly, I have never seen someone in your role at a medical practice that's trying to do the best they can ever get in trouble by the feds or the payers. So I don't think you need to worry too much about that. But the first part of the question is what am I supposed? I mean, am I really supposed to write up the doctor, the owner of my? I mean, how do I even approach her or him on that? And a write-up might be a little aggressive right off the bat. Now this is just me, common sense. I would say, hey, look, doctor, we're going through all of these codes and chart audits and things like that, and I just want to tell you, I think that this may not do too well with regards to if we had a chart audit, and we should really look at it. I'm just looking out for your best interest. That type of thing.
I didn't mean initially. I meant when we got to that.
Okay. Then if it goes on and they don't respond to it or don't put corrective actions in place, I would document that for your own records.
And with that said, it may be more well received if you have another physician that's available to review the charts and talk to them, or a third party.
Absolutely. So that would be something where we're in this situation a lot. They're like, thank God you guys are doing it, because you can sit down with the doctor and say, you can't do this. You can't be prescribing an allergy test every time a kid comes in with a runny nose. So sometimes we are put up to be the bad guys, but most of our people have over 20 years of experience dealing with doctors. We can point out case studies, and we're not bullies either. Hey, here's the information. You do with it what you want. Does that help answer your question a little bit? Okay. Next question.
I just have a question about, what if a parent insists that certain testing be done against the doctor's advice? Is documenting that enough for an insurance company? Because we've had that situation where the doctor says, I don't think it's necessary, and the parent, well, I want it done. I mean, that's a touchy one. Testing is a big thing.
Yep, it is. So if the doctor thinks it's not medically necessary, then you got to go off the doctor's recommendation and advice. I would say very courteously, you can say to them, you may want to get a second opinion, but we don't think it's medically necessary. And by the way, if they really want it and insurance isn't going to pay for it, you can say, we'll perform the test, but it's $411 or whatever the cost. I just made up that number, but whatever the cost is, so they can pay for it out of pocket. I know that's not the answer you wanted to hear, but.
Any other questions? Great. Thank you so much.
Thanks, Leah.
That was really helpful.
Good.
And as Wick said, we do have a table of contents related to the compliance plan that we'll share with you after today's presentation. I believe we've also recorded the presentation, so you can have access if you need to share it with anybody else within your organization. Really quickly, your homework. So I told some of you that I was excited to make the homework really easy today. All we want you to do is designate somebody within your practice as your compliance officer if you don't have one already. If you do have one, even easier, just send us that person's name, and that is due by Friday, June 5th. And if you have any questions, myself or Anna, I think you know how to reach us. I do want to thank you all again for coming. I know there was a lot of information, and I apologize about that. We only have 2 hours, and we're really trying to use this time to get the most information out to you that we can. We will share all the information from today, have some more handouts for you, contact information from our speakers, and if you think of anything else, please don't hesitate to reach out.
Thank you.
Hi.